Alright, diligence. Please be seated. Calling for the case, the golf checkbook Sidian Berhad and others against Nilai Spring Berhad. Is the appellant is here?
Yes, Your Honor.
Nilai Spring Berhad is here?
Yes, Your Honor.
I think we can start the proceeding now. So the plaintiff brought an action against the defendant for breach of contract. The defendant applied to strike out the statement of claim on the ground that the first plaintiff was not privy to the contract as asserted by the plaintiff. It is also delivered a defense and counterclaim. The High Court granted the defendant's application and struck out the statement of claim. The counterclaim was directed to be separately tried. The trial of the counterclaim is set for hearing and disposal on 11 January 2006. This certified with the High Court's order of striking out the claim. The statement of claim, the plaintiff appealed to this court. We heard this appeal on 21st November 2005 and allowed it. So I think we can start the proceeding by having the appellant to start with the opening statement. You may start now.
Thank you, Your Honor. Your Honor, I'm here again to represent my client, Gov Checkbook, against the respondent, Nilai Springs Bahad. My job today is to make an appeal on behalf of my client on the decision made by the High Court. We'll prove that my client is not guilty.
Thank you, lawyer. So I think right now we can start with the opening statement of the respondent.
Thank you, Your Honor. I'm here representing my client, Nilai Springs Bahad, to defend the company from that claim that my client had done the damage towards golf checkbook Sidian Berhad. As ruled by High Court, my client is not guilty, and I believe today that in this appeal court, my client is still not guilty. Thank you.
Thank you, lawyer. So I think the appellant may start with their argument. You may proceed now.
Thank you, Your Honor. Your Honor, my client has already paid the amount owed to the respondent on the 30th of October 1999. The contract was entered between my clients, which is the golf checkbooks and Nilai Springs, where Golf Checkbook has agreed to pay a sum of 80,000 ringgit for the term contract to use the golf course. However, the respondent has breached the contract when he decided to withdraw from the contract. Your Honor, the argument was that my client's company has yet to exist on the contract date. It is true that the company was only incorporated 5 months after the date of contract. However, the contract was done in good faith, since my client has paid the sum amount of 80,000 ringgit to Nilai Spring. Therefore, the contract is valid and the action of returning the money is tantamount to the breach of contract.
Objection, Your Honor.
Overruled.
Your Honor, under the virtue of Section 35, Subsection 1 of the Company Act 1965, which reads, the legal status of pre-incorporation contract is invalid and can be ratified by the virtue of Section 35(1) of the Act. The outsiders are secured when they make contract with the company in good faith. The reason is because pre-incorporation can be ratified under this law.
Objection, Your Honor.
Overruled.
Thus, the payment of sum of 80,000 ringgit is equivalent to the ratification of this contract. Thank you, Your Honor.
Thank you, lawyer. Right now, the defendant may start with the arguments. You can proceed now.
Your Honor, the golf checkbook was not exist when my client entered into the contract with them, and my client was unaware of this fact. Had they known the company was not in existence, they would not proceed. So, Your Honor, if the existence of the company is questionable, how can they enter into a contract since they do not have a legal status as a corporation, and they were not registered as a corporation? Therefore, the contract entered was void. Furthermore, Your Honor, the contract was entered by a party who was not privy to the contract, since the promoter was promoting a company whose existence was not exist on the date of the contract. By virtue of the common law, a company whose legal entity was not exist at the point of date of contract cannot enter into a contract, nor it can appoint any person to enter into a contract on its behalf. According to the case Kellner against Baxter, a company is also incapable of ratifying a pre-registration contract after its incorporation, as it is precondition of ratification that the principle must have been in existence when the contract was made. Thank you, Your Honor.
The issue whether there was a valid, binding and enforceable contract between the first plaintiff and the defendant turns upon the interpretation of the facts surrounding the making of the contract and the application of Section 35, Subsection 1 of the Companies Act 1965. Before us, learned counsel for the plaintiff argued that the payments made by the first plaintiff after its incorporation to the defendant is evidence of conduct amounting to ratification. Therefore, this contract is valid and was done in a good faith. Although it is a precondition of ratification that the principle must have been in existence when the contract was made, that common law rule was laid down in the seminal case of Kellner against Baxter, 1866. The common law could and did produce a logical and unjust result. The Companies Act 1965, unlike its precursors, addressed this issue. By Section 35, Subsection 1, it provided as follows: any contract or other transaction purporting to be entered into by a company prior to its formation or by any person on behalf of the company to its formation may be ratified by the company after its formation, and thereupon the company shall become bound by and entitled to the benefit thereof as if it had been in existence at the date of the contract or other transaction and had been a party thereto. For the reasons already given, the appeal was allowed. The orders of the High Court were set aside and the writ was ordered to be returned to the court. The defendant is ordered to pay the cost of the appeal and those incurred in the court below. The court is adjourned.
Alright.